Okay, welcome everybody. I am Bill Baumeister, and today is the claim drafting webinar portion of the 2025 National Patent Application Drafting Competition. Thank you all for taking time out of your day and showing up. Let's see. Before we get into this, I just say that my understanding is that there's some people here today who've never drafted a claim before, and there's others here who have more experience. Keeping the broad audience in mind, we're going to try to make sure that we have some good tips for everybody. So if you haven't ever drafted a claim, this might be a lot to absorb, but you got to start somewhere. You'll get a lot out of it. And even if you're a pro, one always learns something new every time. About myself, as I said, I am Bill Baumeister. I am an administrative patent judge at the Patent Trial and Appeal Board. For anybody who's not familiar with the structure of the PTO, when an applicant and an examiner disagree as to the allowability of the claims, the applicant can appeal to the Patent Trial and Appeal Board, and the administrative patent judges sit in panels of 3, and we decide whether the examiner's rejection is proper or not. Anyway, I've been here at the board about 16 years. Before that, I was an examiner and a supervisory patent examiner in the area of semiconductors for about a decade. Prior to coming into the office, I worked for a little while on the outside, drafting patent applications, also supervising the law firm search department, patent search department. Here at the office, in addition to my day job, I also teach a course in patent drafting for patent examiners who want to get some experience to see what it's like on the other side of the table. So hopefully I have collected enough experience over these last 3 decades to have picked up some tips that are worth passing along. We do have a question box. I think it's a Q&A box for questions, and I can't see it, but we do have other people online who will be letting me know what the questions are, and we can answer them that way. If there's anything I can't answer, or if the questions come later, you can email your questions to the mailbox npadc@uspto.gov. This is being recorded, and presentation should be available hopefully next week, but that's not within my control. Okay, so down to the subject matter. Here's the overview. Basically 4 parts to the presentation. And as you can see, the questions asked regarding the invention, what you're thinking about before you start. Then we're going to walk through a lot of the law, because that's what controls and dictates everything we do. Then we'll go through some example claims, because all the theory is all well and good, but nothing like actually seeing some concrete examples to have it all make sense. And then we'll go back to a little more theory and strategy for how to approach a patent drafting problem as it arises. I'm not sure if you can see this multimedia viewer. I'm just cleaning up my screen. Okay. One disclaimer: I know nothing about the patent problem that you are going to be assigned for this competition. So if I say something that gives something away, 1, it's purely accidental, and 2, you're welcome. Okay, with that, first part, reviewing the information about the invention before you even start trying to draft your claims or your specification. These are all really valuable tips. I don't know if I'm going to read through all of them, since you have the screen in front of you. You can read them yourself. But I think the point is, you're going to be asking your questions like, what is the invention and what is it made up of? The reason is, you got to have a target or a goal, know what property, your intellectual property, you're trying to protect. Your inventor is going to give you a big disclosure of a lot of relevant things and a lot of less relevant aspects. You're going to have a interaction, discussion, communication with your client to find out, what is it you're trying to protect? What do you want to do with your invention? Are you trying to make, sell, and use it yourself? Are you trying to license it? What are the important aspects of, what is your competition doing? And we're going to get more into this a little later in the discussion towards the end. But you have to figure out what's kind of background noise and what is the crucial, I need to have this idea, concept, elements protected in order to maximize my profits. And we'll get back to this later. So now let's turn to the law. And boy, in 1 hour, we cannot teach you all of the patent laws and strategies that are out there. This is just enough to get the sponge wet so you can go and soak up water with that sponge later. But okay, a non-provisional patent application must have at least one claim particularly pointing out and distinctly defining the invention. You'll be seeing references to 35 U.S.C. 112, 102, 103, 101 throughout this presentation, but that's part of 112. A claim may be written in independent or dependent form. We'll be getting into the whole concept of writing claims out completely and writing them in shorthand form. An independent claim is a standalone claim that contains all the limitations necessary to define the invention. We'll be focusing on the fact that your specification covers a whole lot of information. You don't get protection for what's in your written specification. You only get patent protection for what your claims define, the metes and bounds of the claim protection being sought as set forth in your claims. A dependent claim must refer to a claim previously set forth and must further limit that claim, and we'll do some examples later on of how you can properly shorthand your recitation of your invention in your claim without having to go back and recite everything over and over and over again for your 20 claims that you are allotted. Claim in dependent form incorporates by reference all the limitations of the claim to which it refers. We'll talk about dependent claims. The claims must be supported and enabled by the disclosure. 112A, written description and enablement. We'll be talking about how the language you use in your claims has to also be in your spec. And you really ought to be using the same language and not be using synonyms or making up different words. You're going to want consistency, but we'll get to that. Claims must be drafted as a single sentence. Don't shoot me, I'm just a messenger. I didn't make up that rule, whether you like it or not. That's just a fact of life. And if there's one thing you want to do when you're filing a claim and you're going for that job, make sure it's one sentence. If you're writing multi-sentence claims, someone's going to ask you how you passed the patent bar. Claims should be arranged in order of scope so that the first claim presented is the broadest. Notice the laudatory language should. It's not mandatory language shall. But it just makes life easier when everybody's going through these examinations and appeals. You just look at claim one first. That's where you're first focused on, and it's just kind of what's expected. I've had cases before. I've looked at re-exams where the examiner was giving all the reasons for allowability for claim one, and looking through the application for the claim set further, I saw, oh, lo and behold, claim 5 is broader than claim 1. So all these reasons he said for reasons for allowance they weren't relevant. He allowed stuff that was broader than what he said was the reasons. So it just makes life easier. Things get strange during prosecution when you amend claims, and weird things happen to the claim set, but start out at least trying to make claim 1 your broadest one. Consistent terminology should be used in both the patent disclosure and the claims. I think I already mentioned that. And so, of course, the whole application includes not only your specification and your drawings and your abstract, but also the claims. And as we said, they define the invention and what aspects are legally enforceable. Must conform to the invention as set forth in the remainder of the specification. Comprises terms and phrases that must find clear support or antecedent basis in the description so that the meaning of the terms is clearly understood by reference to the description. This is a lot easier in the biochemical arts where benzene is always benzene. And when you have a chemical, there's a common agreement on what that chemical is called. You get into the electrical arts and you're talking about computer internet network systems, and they have novel functionalities, and people are making up their own terminology. And yes, you can be your own lexicographer, but it makes it kind of tricky for the examiners to search. But there's not an answer. It's not like you're able to use well-defined terms because you're the one who invented them. Well-defined terms don't exist because this is a new invention. But you do want to be as clear as reasonably possible, just so people know what you're talking about. Nobody can read your mind, and if you know what you're talking about, but you haven't explained it well in your spec, then the examiner's not really going to be sure what is it you're trying to protect. Okay, so types of claims. This kind of breaks down product claims into a whole bunch of different synonyms, whether it's active, like a pair of scissors, or a nuclear reactor. They might call them a device or an apparatus. Non-active, I'm thinking my coffee cup, it's ceramic. It's a composition or an article of manufacture. Parts don't move relative to each other. Quite frankly, these are terms, composition, article of manufacture, that appear in 35 U.S.C. 101. There is no real legal significance of, you're never going to get to a legal dispute of, wait, is your invention a device or a composition? It's a thing. It's a tangible, concrete thing that you can see, touch, feel, manipulate. That's what we're looking to get patent protection for. As distinguished from abstract ideas, I invent a paradigm, or math, E equals MC squared. If you come up with something as earth-shattering as E equals MC squared, the good news is you might win a Nobel Prize. The bad news is you don't get patent protection. But that goes to enable patent eligibility under 35 U.S.C. 101. That's a whole discussion for another day. We're going to be focusing on what you're typically envisioning when you think of a utility application, some sort of tangible thing. But you're not limited to claiming things. You can also claim methods or processes, either of making that thing or using that thing. And it's an important distinction. And again, going back to when you have your discussion with your inventor, what is it you are trying to protect? Sometimes I got a new widget. The old, old televisions were only in black and white. I figured out how to make a color television. People are going to flock to mine because it's better. There you want protection, definitely on the product, maybe on the method of making the product. Who knows? It depends. Sometimes the final product is completely known. The destination is no big deal. Yeah, we have this sort of semiconductor device. But what we have figured out is a new way of making it. And instead of doing the steps in the order of A, B, C, D, E, we've come up with a different method where we flip a couple steps and then we get to take a couple steps out. And the benefit is it's a much cheaper manufacturing process. It saves time and money. So we can sell ours for less than the competitor. And in that sense, you definitely want to get a claim for the method of making the product or the apparatus, whether, if the final product is already known, you're not going to get a patent for it. Just the fact that you get a product by a better method, are you claiming the method of the path to get to the end result, or are you claiming the end result? These are things to keep in the back of your mind when you're strategizing on how to draft your claims. In addition to whether it's a product or a method, the next applies to both. Your claim can be written in independent form or dependent form. I think I alluded to. We'll see some examples, but a common one you'll see. I claim a network system comprising a server and a router and a modem and peripherals and X, Y, and Z. And you'll have a whole laundry list. And sometimes these claims can go on for a page. This single sentence goes on for a page, sometimes more. And then, as you know, you get for your base filing fee, you get to have 3 independent claims and 20 claims total, which you can infer means 17 dependent claims. You don't want to write out a whole page over and over and over when you're just adding one little thing like I'm claiming an A, B, C, D. I also want to claim an A, B, C, D, E. I also want to claim an A, B, C, D, E, F. You don't want to have to say that whole thing over and over. Dependent claims are a shorthand, so you can just say, claim 2, I'm claiming the claim of claim 1, further comprising something additional. And it's a much shorter way. You get it in 2 sentences instead of a page and a half. A very valuable tool. Thing to remember about dependent claims is that they include all of the elements of the independent claim from which they depend. Okay, so an independent claim refers to a standalone claim that contains all the limitations necessary to define an invention, and a dependent claim refers to a previous claim and must add a further limitation to the previous claim. And a claim in dependent form incorporates by reference all of the limitations of the claim to which it refers. That part I already mentioned. So adding a further limitation, we'll get into this a little bit further, just a heads up. There's 2 ways you can add more information for your dependent claim. You either add an additional element. Your independent claim says I have elements A, B, C, and your dependent claim says the claim of claim 1 further comprising, or the invention of claim 1 further comprising a D. And so now your invention covers A, B, the combination of A, B, C, and D, which is narrower than just A, B, C. The other way you can limit a claim is you don't have to add an additional element C, but you can say, oh, you know that element A I mentioned before? I want to tell you more about it. Here's something more specific. And we'll get into it more in a minute, but the more you say, the narrower your claim coverage is. For engineers and scientists and people who've taken logic classes, when we start using abstract concepts like a claim comprises A, B, and C, people are suddenly thinking Venn diagrams. Don't be thinking Venn diagrams. Venn diagrams and that sort of Boolean logic is different, and we'll explain that in a minute. But in the patent world, when you say A, B, the more language you put in your claim, the more that has to be there, so the less that it covers. If you say I invent an A, B, and a C, you're not stopping people from selling, making, or using an A, or selling, making, or using a B, or a C individually. You're just stopping them from doing the combination. So a big strategy component as we go forward is thinking about say what you mean and say only what you need to. The more you say, the less valuable your patent protection is. So here are the formalities. Your claims have to start, and why do we have these formalities? It just makes life easier for the examiner. So when you draft your claims, you start on a separate sheet with the heading claim listing. And it's nice for an examiner because then when they go and look at the claims, they can print it out and they don't have to like start with claim 1 overlapping half of the page of the end of your spec. And it's just easier, it's cleaner. Spacing to 1.5 or double spaced. I think that mattered a lot more in the old days when we annotated and marked it up by hand and we printed it out. Whether you're going to get an objection for doing it single spaced, who knows? That's up to the examiner, but don't do it. Just do it 1.5 or 2. It's just easier for everybody to read. Don't worry about it going on for pages and pages. We're familiar with it. That's what claims do. Structure is a single sentence per claim, beginning with a capital letter and ending with a period. I know this seems basic, but we're all a bunch of engineers who went into engineering because we didn't want to go into being English majors. But yeah, make it a complete, proper English sentence following grammar rules. Number consecutively in ascending order. Original numbering preserved throughout prosecution. As I said, you get 20 claims for your basic filing fee. You can pay more for additional ones. But what happens during prosecution is you're going back and forth with the examiner, and the examiner says, you know what, claim 1 is not allowable because here's some prior art, but claim 3 looks allowable. I can't find that. So what you then do is you take all the limitations of claim 3 and you cancel that claim, and you put all those limitations into amended claim 1. And so now your amended claim 1 says everything that was in claim 1 plus everything that was in the now canceled claim 3. After you do that, you still have claims 4 through 20. Do not renumber them. Oh, 3's been canceled. Let's just make this tidy and move it all from 4 to 20 up to 3 to 19. No, don't do that. You have 1, 2, 3 is indicated as canceled, 4 and 20 just as they originally were. Keep the same numbering throughout prosecution. Okay, so now we're going to get into the more fun part of, what is a claim for those of you who haven't actually drafted a claim before. It has 3 parts, the preamble, the transitional phrase, and the claim body. And this is just a little precursor screen to tell you what we'll be talking about in a second. The preamble kind of tells you whether it's going to be a product or a method. The transitional phrase tells you, whether it's open or closed. We'll explain what that means. And then the claim body, that's the meat and potatoes. Those are the elements of your claim that you're trying to seek patent protection for. Every claim needs a preamble, which is an introductory phrase. And generally, okay, now we're getting into a little intermediate patent drafting advice here. The preamble of the claim does not limit the scope of the claim. So let's look at this example. And again, the full claim would probably be a shovel comprising a scoop, fingers, a handle. But so at this point, we're looking at the preamble, a shovel. And they say, do it broadly as a shovel instead of a shovel for digging. Stay away from using this functional language. And there's a couple reasons for that. There's a whole preamble doctrine of, what counts as your claim protection, or the elements that you're seeking claim protection for. Clearly, all of the elements of the body you're seeking claim protection for, and they are limiting. But you have all this language in the preamble, and the question is, are you trying to claim that language, or are you just kind of describing its field of use so we have a picture in our mind of, when I say a widget and a gadget, depending, based on a hinge or something like that, that we're like, what ballpark are we in? What are we talking about? And so a lot of examiners and a lot of attorneys get bogged down in the weeds of what kind of patentable weight should be afforded to all this extra language in the preamble. And I don't want to get into the nuances of, does for digging raise the intended use doctrine? That there's a lot of advanced patent interpretation doctrines that are just way too involved for an hour webinar. But let's make it even more interesting. If instead of said a shovel for digging, it said a shovel of a backhoe. And it raises the question of, does the examiner have to find an entire backhoe, or does the examiner only have to find the elements of the shovel that are in the body of the claim? There's different cases on this, but the long and short of it is it's really murky and it's unclear. The test is, does the language of the preamble breathe life and meaning into the claim? What does that mean? I don't know what that means. As an examiner and as a SPE training other examiners, I just told them, don't start this argument, just go find it. On the outside, what I tell people who are drafting claims is, don't put that claim language in. You're not getting anything extra. It's only confusing the matter. So make it clear, and the less said, the better when it comes to preambles. Transitions, you have an option. After you say that shovel comprising a scoop and fingers and a handle, do you say it comprises those elements, it consists essentially of those elements, or it consists of, or is consisting of? And these matter a lot. Comprising is an open-ended transition phrase. So when you say, I have a shovel that comprises A, B, and C, comprising tells the reader and the courts it has to have at least A, B, and C, but it can have other things. So if I go out and I try to make seller use a shovel that has A, B, C, D, E, you got me. Because you claimed a shovel having A, B, C, I would be infringing your claim. The fact that it has D and E doesn't matter because comprising is open-ended, and it means what you're claiming a stake to is at least A, B, and C. At the other end, and comprising is what you'll see in a vast majority of the time, because you want to keep people from doing your thing plus other things. Consisting of, that's closed. So when I say I have a widget consisting of A, B, and C, that means it has to be only A, B, and C. If somebody makes a widget that includes A, B, C, and D, it's not infringing. And you'll say, why on earth would somebody want to do it closed and use consisting of? That seems so limiting. It comes up a lot in the chemical and the bio arts. So let's say I want a light emitting diode that has an anode and a cathode, and it might have other things like wires and electrodes, but the important part of this is that I have an active layer that emits light, and it is made of gallium nitride. My invention is gallium nitride. It's not gallium indium nitride or aluminum gallium indium nitride phosphide or anything else. It's just the very specific composition, and I want to stop people from using that. So by saying consisting of gallium nitride, I'm excluding the coverage from these other things, these other compositions that aren't what I invented. And you're like, well, why wouldn't you want to be broad? Well, one, you didn't invent it. You're not allowed to claim it if you didn't invent it. And two, the broader you claim, the more available prior art the examiner can use against you. So you don't want to be claiming your invention so broadly that the examiner can apply art against you that you didn't invent, and you're wasting time on prosecution. Consisting essentially of, that's just a weird in-between one. And I can't even think of the term the law uses that it, I wrote this down. Consisting essentially of limits the scope of a claim to those materials that do not materially affect the basic and novel characteristics of the claimed invention. If you have an objective definition of what constitutes materially or basic or novel, please share. I think you're asking for $1 million in litigation to argue that stuff, but if you find a reason why, for example, you might want in the chemical arts, we know that they have impurities, and you can't have something that's 100% pure aluminum. So if I say consisting of aluminum, someone's going to go, mine's a little dirty and it has some of these pollutant additives in it. Not really enough to change the basic structure, but that's just a fact of life in minuscule amounts. You might want to use consisting essentially of in that sort of term or situation. But if you do, please define in your specification, when I say consisting essentially of, I mean this. It can only help define your claim and reduce ambiguity and problems. Okay. So let's see, we still have a half hour. Okay. Now that we got all the parts of the claim, how do you say those things that you're claiming, those elements? Let's take an example. I asked one of you, hey, can you go down to the athletic store and buy me that ball? You'd say, what ball are you talking about? We haven't had a discussion before, and I don't know what's going on in your brain. That's the same thing for patent claims. When you say it's a widget having elements an A, a B, and a C, I am affirmatively reciting the A, B. because, a widget, they haven't been described. The first time you set forth an element, set it forth affirmatively, they call it here in the slides with primary antecedent basis. We're talking about the little words, a and the, that come before the noun. So first time you use a or an, and then when you're referring back to something that you've already set forth, that's when you can use either said or the. I claim a balloon. Claim 2. The balloon of claim 1. And so it's just common English, and the point goes towards indefiniteness of, do we understand what you're talking about? And I think we have some examples a little further, so I'll stop beating that horse for now. Oh yeah, and here are the examples. So it might be, I claim a machine that has 2 levers, a right lever and a left lever. And then my next element is, where in the lever? You're like, wait, which lever are you talking about? So, where in the right lever, or where in the, so use the language that you used up before, and we get into some various situations. I claim a widget comprising an elongated wooden lever, and my claim has no other levers. Later, I can say the lever, and some examiners will say, wait, you didn't say the elongated wooden lever, you only said the lever. Well, yeah, but you know what I'm talking about, because that's the only lever I talked about. But it's safer to use the full term. Sometimes it's okay. Well, look, today's not the day to get into all the little nuances of when you can shorten it, when it's inherent. For these purposes, just be aware of a versus the. The last thing I'll say about that is, do not say wherein the said lever. It's either the lever or said lever. It's never the said lever or said the lever. Pick one or the other. In the former days, when it was much more formalistic, it was expected that you used said instead of the. Nowadays, it's from the past decades. Nobody cares. Just use either one of them and use them properly. Okay, so we've moved away from the law, and now we're moving into some examples to make this a little bit more concrete. I stopped asking why people invent what they do. I just show up to see what's going to happen the next day. So today we have this multiple component headgear system. I wouldn't be caught dead wearing it in public, but to each their own. And here is an example independent claim. So that sets it forth in full, and you see the preamble, a headgear apparatus. You see the transition phrase comprising, which, as you remember, it means it has those 3 elements, the headband, the visor, and the eye shield. Plus, it could have other things. And you'll find when we get to the dependent claims, it does include other things. One thing let's point out, a headband member having a frontal portion. Again, good antecedent basis. They didn't say having the frontal portion. This is the first time they've talked about a frontal portion, and they use the appropriate antecedent basis. Later, we're going to talk about cleaning up your claims and going back through it and getting rid of any unnecessary words that you can. I'm not really clear. I mean, this is a great claim. I'm throwing down my ideas and I put it all out there. Then I stop and I'm analyzing it when I'm going to edit it, and I'm like, a headband member. What is the difference between a headband member versus a headband having a frontal portion? Am I protecting anything more or less by saying a headband member as opposed to a headband? I might be raising confusion by adding the word member. What is it? Why is it there? What is it signifying? I would be making an affirmative conscious decision whether I want to say a headband or a headband member. Same with visor member and eye shield member. And the headgear apparatus, you could have just said a piece of headgear or a headgear comprising. Okay, so now we get to the dependent claims. Again, these are your shorthanded where you didn't have to go and set forth those 3 elements. And you'll see also they use said because they talked about an iShield member before, so you wouldn't say an iShield member. It would beg the question, wait, is this a new one? You're using said because you're referring back to the one you set forth before. You notice claim 3 is another dependent claim, and they both depend from claim 1. That means, claim 1 had elements A, B, C, and claim 2 added element, or it's further specified something more specific about the iShield, so we still have A, B, C. Claim 3 adds a different restriction or further limits it, but it doesn't include the restriction that was in claim 2. So, claim 2 might be ABC specific and claim 3 might be A specific BC, but you get the idea. Claim 3, just because claim 3 is bigger than claim 2 doesn't mean that claim 2 has anything to do with claim 3. We're looking at that portion that says as in claim 1. Which is more important because as you start getting down into your claims, it gets more and more confusing. So now claim 4 is dependent from claim 2. So that means we have all the limitations of claims 1, 2, and 4, not 3. Claim 5 depends from claim 3, which means we have all the limitations of claims 1, 3, and 5, not claim 2 and not claim 4. That's how dependent claims work. There is also a thing called multiple dependent claims. That's beyond the scope of this. Short answer is they're more commonly used in Europe and other parts of the world. Don't use them. Just no good can come from it. And save it for another day to worry about that. So, okay, let's get into another concrete example. And you'll see that this is what happens. Your inventor goes, hey, I got this. Ain't this cool? And you're like, great. What is it? And he might say, well, I call it a doohickey and a thingamabob. And you're sitting here going, how am I going to describe this using words that a third person will objectively agree with me what it means? And I got to come up with terminology and be my own lexicographer. Because this stuff didn't exist before, and they don't have words for anything I'm seeing in front of me. That's where the fun part comes in. That's why you get paid the big bucks. So this is as good as anything. Okay, we're going to call the whole contraption a boot. And you notice this is really indicative of what happens. When you get this, you're going to have a picture, and you're going to start coming up with your own labels. And you're going to be marking this up because you want to be sure that you are consistent from your drawings to your claims to your spec, that you're using the same words, that you're using boot to mean the whole entire combination and frame to mean everything that is not in the propagation mechanism. So we have two subcombinations of a frame and a propagation mechanism that together form the combination of a boot. That's great. You can do that. No problem. Just make sure whatever you call it, you're calling it that consistently throughout. And then we have different buckles, straps, and laces, and you can call them that or Bob for all we care. But the point is, use it consistently. And again, we have a boot, which is the whole combination, and it comprises an open-ended transition phrase, a frame, at least one fastening mechanism. Oh, so we can have one, we're indicating that it can have 1, 2, or 3. And a propagation mechanism, and that's the body of your claim. And so notice how it's not a boot for skating or a boot for inserting your foot or a boot for propelling yourself with a propagation mechanism. They just said a boot. The less said, the better. Okay, so let's just start wrapping this all together. When you write a claim, you want to introduce all of the components and characterizations of the components that are necessary for the invention to work and for it to be different from what was already in the public domain. And we've already used examples of A, B, or C. The important thing is you're having your conversation with the attorney at the beginning of or with your client. You know, what was known? What are you adding? Typically, we don't come up with, aha, I had a dream and I came up with everything in here. Typically, something was known. It might be the conventional roller skates that had 4 wheels in the 2x2 arrangement. And I came up with the idea of having them inline and it's a roller blade. Or roller blades were known, but they were really lousy at being fastened. I came up with that buckle. None of the other ones had a buckle. You want to know what the inventor, all inventions are midgets standing on the shoulders of giants. You want to know what the midget is that your inventor invented. Okay, and again, they're just giving examples of dependent claims, how you want to have connections between your elements, and connecting it either to a different element or the entire structure, or else you're going to further specify a characteristic about the element that was set forth previously. So these are the two ways that you're going to narrow your claim: add more limitations or be more specific about a limitation that was already there. What you don't want to do is have claim one that says, I claim an A, B, and a C. Claim two, the combination of claim one wherein the A is omitted. It only has a B or C. That's bad. That's wrong. That's broadening your claim. It's not narrowing it. 35 U.S.C. 112D says you can't do that. They have to be narrower. Dependent claims have to be narrower. There has to be something the dependent claim infringes that the independent claim does not necessarily infringe. So big takeaway. When you're, let's see, further comprising, let's see if there's anything else. I think we've already covered all of this slide, and we are running short on time. So focus on the inventive concept and how it distinguishes over the prior inventions. Identify fundamental elements. If it's not your inventor's invention, see if you can omit it. Do you have to be in there? There, in the old days, we're talking decades ago, there were issues about if you didn't claim an entire structure, you were claiming a disembodied portion and it might not be complete and you might get rejected. Those days are gone. I have a computer system, and the important thing is that the router has this little fancy widget in it. Widgets were known, but they weren't known to be put in routers. So I can't just claim a router or a widget because they were known independently. So I want to claim it in combination with the router to give an environment so that it makes sense. And this is something that was not known before. It's not the element, but the combinations of these specific elements is what is new and what I'm contributing. But what you don't want to do is start claiming the whole entire network system and, and the servers and the communication towers. You're just narrowing your claim unnecessarily. Omit unnecessary elements. Select broad terms and identify their relationships carefully. Every word in your claim matters. If you haven't picked this up in the last 40 minutes, please do so now. Don't just, I can't really think of the right word to use, so if I just say it 3 or 4 times, like in law, how they say, do not fold, spindle, or mutilate, and they just want to throw a whole lot of synonyms and figure I'll capture it that way. And, if I say enough, they'll get the general idea. Don't do that in patent claiming, because then you're just going to beg the question of what do all these different terms mean and how do they differ from each other, and what, does it have to have all 3? Pick precisely what you want to say. Don't say any more. And it's hard. It's really hard. It's really hard. And you'll find yourself when you're drafting claims just sitting there going way off in space, and you can drive yourself crazy. That's normal. That's part of the process. When you take a good stab, set it aside, just like proofreading a term paper or a brief, then pick it up again, see what, if it says what you thought it says. And you're not going to be able to do it right. That's why we have examiners, because you're so focused on saying, how do I describe this thing? It doesn't even occur to you that it also reads on something else. It's like, that didn't occur to me. That's not what I intended. And the examiner goes, yeah, that's why I'm here. I'm telling you, it also reads on that. And I know that's not what you intended, and that's why I'm rejecting it. Go back and try again. Okay. Novel, non-obvious, and utility. These are 35 U.S.C. 102, 103, and 101. We don't have time to go into that. We did mention for utility, there's only certain types of things that that are eligible for patent protection, but that's a whole rabbit hole. Okay, a patent is not a marketing brochure. Sometimes, I mean, it shouldn't be, but sometimes people go, I don't care if I actually get a patent, I just have to be able to say patent pending so that I can get my investors involved. We're not worried about those sort of commercial games. What you're interested in is actually a valid patent that actually has legal enforceability. Which, you know, yes, there are marketing aspects, and yes, you're going to have to be savvy, and you don't want to say things in your spec that make it sound like your invention isn't really the best thing since sliced bread, but that's all the icing on the cake. It's not the cake itself. And okay, so we already talked about the last bullet. And as part of your having discussions with the inventor, I mean, that's an art in and of itself, because the inventor does not understand patent prosecution. You are their counselor, you are their shepherd, you are helping them through the dark woods to get to the promised land of having a issued patent. So you have to ask them questions that they'll tell you things, but they don't even think of telling you certain things, and you have to know what to ask. You know, like, what are the competitors doing? You know, and then, you know, what's your backup plan? If I can't get patent protection on this, are there any bottlenecks? Are there any ways that you can claim something additional in combination? It's narrower, but still you're going to forestall your competition from being able to do this. Doing a patent search, seeing what's out there. Everything sounds great when they tell you, oh, I've never heard of anything like this before. You know how many people have gone, oh, you're a patent attorney? I had this great idea. And I go, good news and bad news. The good news is that's a really great idea. The bad news is it's such a great idea, there's a whole subclass of that invention at the patent office. Heated steering wheel covers, automatic toilet seat lifters. You know, it's like everybody comes up, you know, doesn't mean it's a dumb idea. It's a great idea. Everybody thought it was a great idea. So do a patentability search before you start drafting your claims. Alternative embodiments. You don't want to limit it to buttons only to have your competitor use snaps and totally avoid your patent claim because you didn't think ahead to use a generic term like fasteners. So part of your, and you're the patent attorney, you're not the inventor, you don't understand this technology. You're the translator that translates really good ideas into patentese that the patent office understands. But you have to be thinking, asking the inventor, how else can you do it? Are there other ways? Are there benefits to the other ways? Are there drawbacks? And then you decide, you know, what do you want to cover? What do you want to drop out? Do you want to have them in multiple applications? Do you want to have one big application that covers a whole bunch of embodiments? And you might have to worry then about, is the office going to, I'm going to claim everything and see if the office restricts it into multiple inventions. That's all strategy that comes down the line, but you have to be thinking about these things. Now here's a nice graph of the Goldilocks principle. As I mentioned earlier, the more elements you have in a claim, the narrower it is. If I claim a substrate, anything that has a substrate is covered by my claim. The good news is that covers basically everything from a roadway to a desk, to a telephone. The bad news is it's too general and it's not going to be patentable. So if I start claiming really narrowly, I'll probably get a picture claim, but that picture claim is useless because my competitors can draft around it. So I don't want it not too hot, not too cold. I want it just right. A very valuable piece of advice I got when taking the patent bar review course was, if you are drafting patent claims for real, you're going to want to have some claims that you know probably are too broad and some that you know are probably too narrow as safety backups. Just like when you apply to law school, you apply to some that your safety schools, too general, the ones you know you'll get into, and you apply to some dream schools that are reach that you know you won't get into, but you never know. And then you focus your attention on what you think is just right. You know, And the reason you do that for patent claiming is if you get a first action allowance, you did something wrong. You gave up white space, something you might have possibly given up some, you could have gone broader, but you don't know. So if you start with really broad claims, some medium scope claims, and some narrow claims, you're kind of expecting, you're not admitting it to the patent office, but you're expecting that those broad claims are probably going to get knocked out in the first round of prosecution. No hard, and probably a good idea to warn your client, let them know that this is what your strategy is so they don't get upset when you show them that first office action with some rejections in it. Yeah, I know they were coming. We talked about this. The point was we thought claim 2 or independent claim 11 was really the medium one that we're really going for. And then you can gauge based on what the office found. Was I right? Was I wrong? Did I have to go to plan C and go to the specific one? But you have options to discuss with your client by using a whole range. So I saw a bit of a comment. I think it was, can you claim apparatus and method claims? I don't know if we covered that or if I skipped over that, but yes, in the same patent application claim set, you have 20 claims. They can be any combination. Claim 1 can be a product claim. Claim 2 can be a method claim. And they have things, product by process claims, and it gets a little more weedy, and we won't go there. But what you do not want to do is have a claim that is a hybrid claim where one single individual claim has one portion that says, a preamble. I claim a widget comprising a handle, a substrate, and a method of using these to dig a ditch. Then you're mixing statutory classes of products and methods. You can't do that. It raises indefiniteness questions of, what were you intending to cover? The statute says you can claim a product or a method, one statutory class per claim. So don't mix and match, but you can have, and you definitely should. And part of your whole strategy of being broad and specific, have some claims to products, some claims to methods, because they're going to claim different things. The path to the final product and the final product are two different scopes of coverage, as we discussed before, why you can infringe one without infringing the other. So yeah, that's your strategy. See what you can cover and hit. And so here we have an example of you're trying to claim all of these, and what kind of claim language should you use that will cover all of these. And so the example they have is a boot comprising a frame, at least one fastening mechanism, and a propagation mechanism. And we've used generic terms that covers all of these. And then the examiner comes and he finds the CCM hockey skate as prior art. And now you have to amend the claim and get rid of that. So you can change it and narrow it by adding a limitation, wherein the propagation mechanism consists of 4 wheels attached to the frame. That excludes a blade. You don't want to go narrower, but you have to in order to overcome the prior art. Here's another option. You might have to go even narrower because, in the 20th century, both the old roller skate quads and the ice skates were known. Mine's an inline skate. So wherein the propagation mechanism consists of 4 wheels attached and the 4 wheels are arranged in a straight line. If we had more time, we could get into an example of how would you do both the hockey skate and the roller blade, excluding the quad skate. That's something for you to think about. And it raises questions of how would you define that? And if you hadn't thought that might be a possibility, and you're trying to claim it now, where's the support in your spec for the language that you want to use to define it? So these are things that you want to be thinking about before you even start drafting, because once you file that specification, you're kind of stuck with what you got. You can't be adding things later on, because your goal is to show that the inventor had possession of the invention at the time of the filing, not 2 years later when the examiner gives them a rejection. Okay, so we're coming to the end, and these are just some, reminder do's and don'ts. I think we've covered everything here. Point out, distinctly claim the subject matter. review and reconcile the claims. You want them to say the same thing so that you have support, and you're not adding new language. What's common, like after you file your amendment and you're trying to overcome your claim and you're trying to come up with a way to distinguish those skates from the prior art, and you want to say something new based on the drawings, or and the examiner's like, I don't see that in the spec. And then you get into issues of, well, do the drawings provide sufficient support? You want to avoid that. You may win, you may lose. Ensure that each term has proper antecedent basis. Look at the claims and patents issued in your field of technology. That can really help because it gives you an idea of what people in the field are using as terminology. And when possible, it might be a good idea to use the same terminology, or at least consider using it, because that's what the examiner and the public are going to expect. And I had, back as an examiner once, I had an inventor just making up his own. He said X. And when he said X, he meant really, really, really narrow X. But the whole industry, when you said X, it was so broad. He tried to put this claim, and I didn't even find an art. I just gave him a rejection saying, this claim is so broad, it reads on every piece of art in this particular subclass that has a good date. I wasn't even going to go waste my time. I wanted him to know, look, you're using a term badly. Come back, when you want to be serious and start thinking about the words you're using. Think about legal protection you need for your invention, and you only know that by talking to your inventor. Ensure dependent claims further limit. We talked about that. And the don'ts. As we mentioned in response to that question, do not use claims covering 2 statutory classes. Do not use terms inconsistently. Do not use terms in the claim that are unsupported. Do not write multiple sentence claims. Please don't do that. You're just asking for somebody to raise an eyebrow. Do not use functional language that is unconnected to the structure or steps. That's getting a little advanced and getting into what constitutes functional language versus a description of structure. We can have philosophical debates about that till the cows come home. Yeah, let's just leave that aside for now. Do not replace a claimed element as a limitation of a dependent claim. Like we said, you can't take an element away and you can't swap or substitute a different element. Do not refer back to only a portion of another claim. Claim 1 is to a whole system, including a widget, and you can't say, I'm claiming claim 2, the widget of the apparatus of claim 1. No, it has to be the whole entire kit and caboodle, the whole claim 1. Trademarks and trade names, don't use Velcro, use hook and fastener, because trademarks denote a provider or a source of a good or service. They do not define. Think of Coke and New Coke. You know who makes it, you don't know what's in it. And people are allowed, trademark owners are allowed to change the composition or the concoction, or what Coke means can change over time. If you use a trademark, it's a relative term and it does not have objective meaning. And the examiner, if they're paying attention, should give you a rejection for being indefinite for using relative terminology, which means you have to know what's actually, is a copier machine as opposed to Xerox, Kleenex. That's a proper term. So you have to be a bit familiar with trademarks and make sure when you're talking to your inventor that they're using hook and, they'll say, oh, I'm using Velcro. And you say, okay, and you write it as hook and loop fastener. Do not use language that merely suggests or makes optional a feature, an A and a B and optionally a C. That's a way to get an indefiniteness rejection because you can't do it optionally. You can do things conditionally. A circuit so that which does X upon a precondition of Y. There's a difference between being conditional and being optional. Avoid optional. Avoid using negative limitations unless clearly supported by the written disclosure. There's a whole body of case law when you can say an A, a B, but not including a C. It has to be expressly or disclosed in the spec, and it gets really messy, and it typically happens when you're not thinking of that and you want to add it later. try your best to avoid that situation. That's going to take some legal research. To summarize, and right at 4 o'clock, the questions you need to answer before claiming your invention is one of the things you should understand. Also, the format and structure of independent and dependent claims, and possible methods of drafting your claims. Here is the QR code for the survey, and with that, I'm ready to open it up for questions. Thank you for your time. I hope you found it informative. I'm not sure if Yoon or somebody else online has questions, or if I'm supposed to be looking somewhere.
Yeah, there's one question about if the invention disclosure talk about process or feature that does not describe how the process or feature is actually carried out, may we provide prosthetic explanations to address any enablement issues with regard to like the invention statement in a competition?
Okay, I'm not going to tell you what you can or can't do for the competition because I don't know what the rules are, and I don't know what the problem is, and I don't know what the expectations are, and I don't want to get you in any trouble and have you blame me. In real world, it's common that the inventor will not tell you everything, and you might have to do that little fleshing out of, well, you said this, I don't quite understand how that works. You're the expert. Can you explain it to me? Because inventor, we have to make sure that we disclose your invention in a manner that shows the public how to make and use it. And if we don't, your patent will get invalidated. So please tell me how to do that. But I'm guessing, and this is, don't hold me to this, but you have a closed record for whatever your problem is. And if it's not in there, you're definitely not allowed to, there's a line between describing something that is already disclosed, and you can use synonyms that don't change the meaning. I can say 12 or a dozen, but if they say 12, I can't change it to a bunch. And you can't be changing the scope of the disclosure after the ship has sailed, after your file has, your application has been filed. Other questions?
No, that's the only question there.
Awesome. Okay. Well, I do hope this has been useful. And if other questions come to you in the future, I believe we gave you the email address, which again is npadc@uspto.gov. And if any more questions come in, we'll find a way to have those answers made available. Again, this recording should be available maybe next week, but I'm guessing at that. Don't hold me to that. So with that, thank you all very much. Good luck with the competition. I hope you all do great. Expect it to be hard and expect to learn a lot.